So, what happens to all your stuff when you're gone, if you don't have a will? A lot of people think no will just means, well, no plan. But you'd be wrong. Oh, there's a plan, all right. The state has one already for you, and today we're going to pull back the curtain on this default plan you never even knew you had.
Wow, this quote, it really says it all, doesn't it? It comes from a lawyer who was right in the middle of this heartbreaking case. There are no feelings, no empathy in the law. It just looks at the kinship chart. Think about that. It's just a system of cold, hard rules. It doesn't care about the life you actually lived or the people you really called family.
Okay, so that brings us to our first section, a plan you didn't make. And to really get what's at stake here, we have to talk about the story of Marcelle Harrison. Her family got caught in this exact system, and they found themselves fighting for the one thing that meant everything to them, their home.
So get this. The Harrison family lived in their Cambridge home for almost 40 years. I mean, that's your whole universe right there. But then Marcel's stepfather, Noel, passed away, and he didn't have a will. And that's when this cold, harsh legal reality just slammed down on them. See, as his stepdaughter, the law said Marcel wasn't a legal heir. It didn't matter that he raised her. The law just pulled out that kinship chart and followed the bloodline all the way to Noel's relatives in Barbados, people he barely even knew. And just like that, they were named the owners of this $1 million-plus home. All those decades of love and family, legally, it meant nothing. Absolutely nothing.
And look, the Harrison story is absolutely tragic, but here's the kicker. It's not some rare one-in-a-million thing. Far from it. Over half, that's right, more than 50% of adults in the U.S. die without a will. That means millions of families are thrown into this exact same default system, and most of them have no idea what the rules even are. There's a legal word for this whole situation. It's called intestacy. And really, all it is the state's default plan for your stuff when you die without leaving your own instructions. Now, the idea behind it sounds okay, right? It's trying to guess what the probable intent of the average person would be. But here's the problem. Who is the average person? The reality is, it's like the government handing you a one-size-fits-all t-shirt that, well, it fits absolutely no one. It just can't handle the beautiful, messy complexities of modern families. So how does this whole default system actually work? Let's dive into that in Section 2, the default family tree. Because believe me, every state has a very clear hierarchy, a kind of pecking order for who gets your property. All right, this chart lays it all out pretty clearly. The law starts at the top. First, it looks for a surviving spouse. They're usually first in line for a big share, if not all of it. There's no spouse, okay, then it goes down to your kids, or even your grandkids. No kids? The law then looks up the family tree, to your parents. After that, it goes sideways to your siblings and their kids, your nieces and nephews. And if they go through all of that and can't find a single relative, well, that's when you hit the last step, escheat. And that's a fancy word for the state gets everything.
Okay, let's zoom in on that very first step. Section 3, the spouse's share. Now, this sounds like it should be the simplest part, right? But it gets complicated, and it gets complicated fast, especially when you're talking about blended families.
So here you can see how the law tries to handle two different scenarios. On one side, you've got what we might call a traditional family. If all your kids are also your surviving spouse's kids, the law usually says, okay, the spouse gets everything. The logic is, they're going to take care of their own children. But what about a blended family? This is where it gets tricky. If you or your spouse have kids from a previous relationship, the law suddenly gets protective. It recognizes that there could be divided loyalties. So to make sure your kids are protected, a chunk of the estate often goes directly to them. And that, of course, means the spouse's share gets smaller.
All right, so let's say the inheritance is going to the kids. But how exactly is it divided up? This brings up a really common and kind of tricky family puzzle. What if one of your children passes away before you do, but they had kids of their own, your grandkids?
This is a huge question, and every state has to have an answer for it. So do those grandkids just split what their parent would have gotten, or does every single grandchild get an equal slice of the pie? And the wild thing is the answer completely depends on what state you live in. And this is where it gets really interesting. This chart shows the three main system states use. Okay, look at that first one, English per stirps. The idea here is that the inheritance is split at your kid's level. So child B's line gets half, and child C's line gets half. That means grandchild D, who's the only one in their line, gets that entire half. Meanwhile, E and F have to split their parents' half, so they each only get a quarter. Now, a lot of states looked at that and said, that doesn't seem fair. So they came up with modern per stirps. Here, the estate is split equally at the first generation where there's someone living. In this case, the grandkids. So D, E, and F each get a perfect 1/3. It's totally different. The main takeaway here is just how much your zip code matters. The same exact family could see 3 wildly different outcomes.
And if you think that's complicated, well, it gets even weirder. The law has had to grapple with some truly bizarre, out-there situations. And let me tell you, the results can be pretty shocking.
Okay, take the really grim scenario of a simultaneous death. The old rule was, honestly, it was kind of gruesome. You needed sufficient evidence to prove who died first, even if it was just by a fraction of a second. This led to these awful court battles. I mean, there was a famous case related to the Tylenol poisonings where doctors were on the stand testifying about heartbeats and pupil responses, all to figure out who officially died first and who got the life insurance money. It was terrible. So to prevent that nightmare, most states came up with a much cleaner solution, the 120-hour rule. Basically, to inherit, you have to survive the other person by 120 hours. That's 5 days. If you don't, the law just treats it as if you died first. It's a simple, logical rule that stops families from fighting over minutes and seconds.
All right, next up is a question that sounds like it was ripped straight from a daytime soap opera. Can you adopt your own spouse to make them an heir in a family trust? It sounds absurd, right? But you'd be surprised. People have actually tried it.
So in this really famous case, a son literally adopted his own wife, so she would technically become an heir to his mother's trust. But the court basically said, no way. They called it a subterfuge, which is just a fancy legal term for a scheme or a trick, and said it completely went against what his mother wanted. It's a great reminder that courts can and will step in when people try to use the law to manipulate an inheritance.
And that brings us right back to where we started this whole conversation, stepchildren. You know, just like we saw with the Harrison family's painful story, the state's default plan is built almost entirely on bloodlines. In the eyes of the law in most states, a stepchild is a legal stranger. The only way around that is to explicitly name them in a will. There are a few rare exceptions, but basically they'd only inherit if the state literally can't find a single blood relative anywhere on the planet.
Okay, so we've been through all these complicated, sometimes really harsh, and often surprising rules. So what's the big takeaway here? What's the point of all this? Well, that brings us to our last section, escaping the default.
Look, here's the bottom line. The state's default plan, intestacy, is a blunt instrument. That's the best way to put it. It cannot possibly understand your unique family. It doesn't know about the stepchild you raised as your own, or the sibling you haven't spoken to in 20 years, or the best friend who's been more family to you than anyone. It just follows a rigid, old-fashioned script based on blood, period. So the only way, and I mean the only way to make sure your actual wishes are followed, is to write them down, to create your own plan.
And that leaves us with one last big idea to chew on. The law is always playing catch-up. It's always years, sometimes even decades, behind how we actually live our lives. Our society changes, our definition of family changes, but these legal default settings, they are incredibly slow to adapt. So the real question you have to ask yourself is this: is your estate plan, or, let's be honest, your lack of one, built for the actual family you have today? Or is it running on an outdated template from 50 years ago? Only you can answer that.